For centuries, the family justice system relied on physical proximity. Its foundations were oak courtrooms, massive paper files, and the mandatory presence of every party in a dispute. In early 2020, that physical machinery ground to a halt. The national lockdown made the core requirement of the court, in-person attendance, a legal impossibility. This created an immediate crisis. For families requiring urgent child protection or domestic abuse interventions, the closure of physical buildings effectively cut off access to judicial protection. The system adapted through the landmark case of EK, which provided the forced proof of concept the legal system required. EK involved a complex, multi-party final hearing in care proceedings. Rather than adjourning, the court executed the entire trial via Skype for Business, proving that software could sustain the most high-stakes family litigation. What began as an emergency stopgap has since been codified into permanent, standard procedure. Understanding this transition is critical because the digital pipeline now controls every point of access to a judge. The statutes govern the law, but the medium governs the procedure. The traditional image of a trial has been hollowed out. In its place is a decentralized system where physical location is secondary to digital connection. The single-family court now operates as a national entity. It routes the majority of its business through a centralized digital network rather than a cluster of local buildings. This infrastructure functions in three distinct phases: portal initiation, digital gatekeeping, and the remote hearing. Each phase carries unique procedural traps. In a virtual system, a technical oversight can be as damaging to a case as a failure in legal argument. The modern court offers speed and physical safety, but it demands absolute technical compliance in return. Phase 1 is initiation. The physical filing of paper applications is largely a relic of the past. The Divorce, Dissolution, and Separation Act 2020 standardized this shift, moving the entire process for ending a marriage into the digital domain. Legal professionals are now required to use the MyHMCTS online portal for these applications. Under the Practice Direction 36N pilot scheme, applications for financial remedies, including Form A, are forced through this digital bottleneck. The portal centralizes incoming data, feeding it to a gatekeeping team. This team sorts cases by complexity, allocating them to the appropriate judicial level. This centralization accelerates applications and eliminates the backlogs that once plagued regional courts. While the court benefits from this reduced friction, the administrative burden has shifted. Flawless front-end data entry is now the sole responsibility of the practitioner. When a case reaches Phase 3, the hearing, the digital architecture brings geographically distant participants into a single virtual courtroom. Guidance from the president of the Family Division dictates that directions appointments, financial cases, and dispute resolutions are now routinely held remotely. This allows practitioners to manage multiple cases across different regions in a single day, increasing the efficiency of the legal market. However, the most significant advantage is the physical protection of the vulnerable. Practice Direction Part 3A governs vulnerability and participation, specifically in cases involving domestic abuse. The Live Link feature provides a legal shield. It delivers testimony to the judge while protecting a victim from the trauma of physical proximity or direct eye contact with their abuser. By weaponizing geographic distance, the digital architecture alters the power dynamics of the case to provide safety for those at risk. Remote efficiency relies on a massive transfer of labor. Court clerks no longer prepare the physical courtroom. The applicant's lawyer is now legally responsible for all technical arrangements. This includes the most dangerous compliance trap in modern family law, the e-bundle. Practice Direction 27A sets strict, unforgiving parameters for these files. The bundle must be a single, text-searchable PDF with perfect pagination. It is also subject to an absolute 350-page limit. Judges treat technical noncompliance as a direct waste of the court's time and will penalize it accordingly. Bundle failures can trigger wasted cost orders, where the court requires the lawyer or firm to personally pay the opposing side's fees. In the digital family court, technical formatting errors are treated with the same severity as fatal flaws in legal argument. The digital interface creates a psychological danger, the false sense of informality. Clients participating from their own homes or vehicles often fail to recognize the gravity of the proceedings. Every remote hearing maintains the legal weight and formal requirements of a physical trial. This includes a strict prohibition on the unauthorized recording or broadcasting of the proceedings. Taking a screenshot or recording audio is a contempt of court, punishable by severe legal penalties. Practitioners now have a duty to ensure their clients are alone in a secure room, personally enforcing the privacy of the virtual courtroom. In this system, the lawyer must act as both legal counsel and digital bailiff. The modern single-family court is defined by the tension between its accessibility and its technical rigor. Tools like the MyHMTST portal and FPR Live links speed up the bureaucracy and protect the vulnerable. But that efficiency is balanced against the reality of wasted costs orders for those who fail to master a text-searchable PDF. Success in family law now